Okay, good morning, everyone. Welcome to Collier County Court. I'm Judge Martin. We have one matter on the 10 a.m. docket this morning, which is Sandbanks versus Sisson. Ian, can I get counsel's appearance for the plaintiff, please?
Yes, Judge. Doug Wood on behalf of the plaintiff.
Okay, and do I have anybody present on behalf of the defense? Is Mr. Carr? It shows John Carr.
Yes. Judge Mr. Carr and Kim, who you see on there, are both witnesses for the plaintiff.
Okay, all right. All right, let me just make sure that I've got the names for the record. So John Carr and then Kim, what is your full name? Or are you court reporting or are you a witness?
No, Judge, I'm with the property management company. My full name is Kim Gaglia. It's Gaglia.
Okay. Sorry, you were looking down almost like you were the stenographer for our proceedings. So, okay, so I have John Carr and Kim Gaglia as witnesses with Mr. Wood as counsel. So at the moment, I don't appear to have anybody for the defense present. Mr. Wood, I do note that the defense appears to have been making payments to the registry. I'm not sure if you were keeping an eye on that or not. Is that news to you?
I know she made after your order, she made the first payment to the registry. Did she make the January payment to the registry as well?
January 4th, and let me get the net amount because what I can see on my first screen includes clerk fees. So there was a 1978-19, that was in December. And then January 4th, which was the first business day of January, 1534.19.
Okay.
Was deposited. So I have no idea if that relates to what was due in any meaningful way, but, and I didn't know if Robin Sisson was male or female, but.
She's female.
Okay. So I have an answer, I have payments. I had perhaps a naive optimism that perhaps there could be some sort of agreement or settlement here. It's a rare scenario where I actually have someone trying to keep rent paid, but how do you wish to proceed, Mr. Wood, or would you like to consult with your client for a moment?
Mr. Carr is my client along with being a witness. Judge, and it wasn't an attorney of record. Ms. Sisson did have an attorney early on.
Okay.
He never filed as an attorney of record. And he and I had some conversations, which I thought were productive, but then he chose not to represent Ms. Sisson. I did reach out to Ms. Sisson early on to try to reach a resolution, but I was unsuccessful in doing so, and haven't heard from her since. We have been, the email that you sent to her, the order directing the payment of rent to, is the email that I have been using. It's an email that I have used for her previously, which she did respond to. But she has not, as a matter of fact, I think it was early this week or last week, I had forwarded the proposed exhibits for today to your assistant and copied Ms. Sisson on that, and she did not respond to that as well. We'd like to just go ahead and proceed with the eviction. The issue here, Judge, is Ms. Sisson has been continuously late with rent throughout the rental history. She actually had paid some bad checks that were insufficient funds. She was late. She was behind on her rent in November. On November the 12th, or prior to November 12th, the plaintiff's management company prepared a 3-day notice. Actually, on the 9th of November, it was mailed out by certified mail to Ms. Sisson and signed for on the 12th of November, which was a Thursday. She did not make a payment. Ms. Sisson did not make a payment within that 3-day period. We filed suit after that on the 18th of November. After that, on the I believe it was the 19th of November, Ms.
To interrupt, but there is somebody else joining. I'm not sure.
Okay.
It's a generic Samsung name. So.
Oh, that looks like that's probably her.
Okay, I don't know if you can hear us, but it looks like your audio is still trying to connect. Again, I don't know if Ms. Sisson can hear us. The indication I'm getting is the audio didn't connect. Can you hear us now, Ms. Sisson? Will you give me a thumbs up if you can hear us? I'll try again. Ms. Sisson, are you able to hear us now? If you can, give us a thumbs up. Appears to be freezing up. I thank everyone for your patience. This has been something that happens on occasion. Ms. Sisson, can you hear us? Okay, I can read your lips. You are muted. If you will unmute, we might be all set. Let's see.
Okay, I just did, came up unmuted. I apologize, this is my first time doing this.
Okay, that's fine. I can hear you and see you, so that's good. We did start right at 10 o'clock. I was noting for Mr. Wood, who has his plaintiff and his property manager present. I was noting that you have made, I think, 2 payments into the registry, one December 4 and one January 4. I think the plaintiffs were unaware that you had made that January 4 payment, and they were giving me a bit of an overview. So I will ask Mr. Wood to sort of reset, if you will. I thank you for your patience here. And if you'll state for the court what the plaintiff's goals are here today.
Yes, Judge. As I indicated earlier, I think you'll see from the testimony in one of the exhibits, Ms. Sisson has a history of either paying late or making partial rent payments in the past. And within the past year, she's also made some payments that came back as insufficient funds, leaving a balance that she owed. In November, she didn't make the November 1st rent payment on time, and again had a balance that was owed. So the property management company for the plaintiff prepared and mailed out by certified mail a 3-day notice. The 3-day notice was done properly pursuant to the statute and the lease. It was prepared on November 9th and signed for by the defendant on November 12th. And the amount that was due in the past due rent was $2,769.30. No payment was made within the 3-day period, and that's including the 2 weekend days. So suit was filed on November 18th. On November 19th, Ms. Sisson attempted to deliver a $1,800 check for rent, which was not the full amount of past due rent that was owed, and it was not accepted by the plaintiff for 2 reasons. One is because it was late, it was beyond the 3-day period, and they'd already filed suit, and 2, it was not for the full amount. And I think for 3, the third reason is because, again, there was a history of either non-payment of rent or making only partial payments. And so that's why we're here today, Judge, is for the count 1, which is the eviction, because of the fact that the defendant did not timely pay November's rent and did not timely pay pursuant to the 3-day notice.
Okay. And Ms. Sisson, just to sort of translate a little bit, Mr. Wood has given an overview. If we wish, I can swear the property manager and the client in. I am, I'm assuming we would certainly be able to verify that the witnesses will testify consistent to that. I think Mr. Wood just offered sort of an overview to sort of tell the court the angle from which the plaintiff is approaching this. Do you want to give me an overview? Do you dispute any of what Mr. Wood just summarized in terms of the history here? You are, I think you're muted again.
Okay, can you hear me now?
I can.
Yes, ma'am, I dispute it all. I have been a on-time payer for 5 years. I put $19,842.24 into that unit to make it right for me.
Okay.
I started when I was late. It was only because of the shutdown and the COVID, and that is part of it.
Okay.
And property management kept construction on that property for the last year, which has definitely affected all of our businesses. And then in December, they gave us a letter, which was last December, they gave us a letter that says they're kicking us all out in 6 months, no recourse. And this was prior to the pandemic, which started January shutdown.
Okay.
So the signs went up for the building to be torn down and us to be kicked out, which started less business for me. But I still maintained all the way through July, when I did become somewhat late, but consistently paid and consistently on time, was talking with property management code. By then they'd switched me to talk to Leona, which I guess now was a setup. That's how I look at it.
Let's do this. Let me interrupt you because I need to get everybody under oath, and we'll take some formal testimony. I do want to kind of just give everybody a little bit of information about Florida law and where things stand, just so you all understand going into this what I can use and what I can't use. First, COVID. COVID has been made relevant by certain government emergency orders only with regard to residential. This commercial eviction, from what everybody's telling me, so COVID is not legally in play. Second, Florida eviction law is incredibly technical. It has absolutely no heart. It gives me no power to have any heart. If Mr. Wood is able to prove that rent was outstanding in any amount and was not caught up by the end of the 3-day notice, we're pretty much done. Most of everything that you have said so far, Ms. Sisson, while emotionally, compelling, is not legally relevant. What
Well,
you've invested to fix up the commercial property is not something I can consider. I can't convert that into rent or anything like that. So Mr. Wood needs to try to prove that there's been a failure to pay, and that's going to probably be the end of what I can consider. All of the other stuff may be very compelling, but it won't be legally.
Okay, but they have a $4,280,000 deposit always on me.
That's for
And
security. That won't be relevant either.
And the conversation was they were giving me opportunity, and they knew exactly when I had the money to pay, and they would post me prior to that. But I am on time now. I have paid up to date. This is all I have. And they have the $1,800 check that's still money's there. And at that point, Leona told me late fees, I was up to date on the $1,800 check. The late fees were the extra amount they're saying I owe. It was not rent.
Okay, but that also, now that we're in litigation, Florida law makes you liable for reasonable attorney's fees. I don't know what the fees amount will be.
He's wanting all my deposit.
Okay.
Mr. Woods is wanting all my deposit.
They'll have to prove that up, but I want to let you know it is, at least it's not coming out of thin air. That is Florida law. It is again very technical and relatively heartless, and you can imagine what's going on the residential side of the world right now. This is a commercial one. I do
know other property managers are being with a person like me. They have been very helpful because I always pay.
Okay.
I always pay.
Let me get this. Let me have Ms. Gaglia, Mr. Carr, and Ms. Sisson. If you all want to raise your right hand, I'll get you all sworn in. Do all three of you solemnly swear or affirm that your testimony will be the truth, the whole truth, and nothing but the truth today?
I do.
Yes, sir.
Okay. Mr. Wood, if you want to inquire, we'll go ahead and proceed. I think I've spent a few minutes here just trying to figure out if there was any chance of agreement. Ms. Sisson, even before you got on, I let them know you've been paying rent to the court, and is there a chance of agreement? And I'm gathering now from hearing from both of you that there's probably not much chance that there's going to be an agreement here. So
that's because they can get more rent for my building. They're kicking me out so they can get more rent. They've done nothing but tell me what a bad person I've been since COVID's taken over. I have letters to prove it.
We're gonna go in order here. And again, I'm just gonna remind you, none of that is anything that I can step in and address. I'm not here to figure out who's a good guy or a bad guy. Either the plaintiff can prove their case or they can't. That's my only line of inquiry. So Mr. Wood, you can call your first witness, please.
Thank you, Judge. Call Mr. Carr.
Okay, Mr. Carr's been sworn.
Mr. Carr, can you give us your full name for the record, please?
John Ambrose Carr.
And Mr. Carr, are you affiliated with the plaintiff Sandbanks LLC?
Yes.
And how are you affiliated with the plaintiff?
I'm the manager.
Okay. And Mr. Carr, did you receive the exhibits that I had provided to the court and to yourself?
Yes.
Do you have Exhibit 1 in front of you?
The commercial lease agreement.
Do you recognize that document?
Yes.
What is it?
A commercial lease agreement between Sandbanks LLC and Robin Sissons.
So is that the lease agreement, the current lease agreement between your company and the defendant, Ms. Sissons?
Yes.
And if you turn to the last page of that exhibit, do you recognize that document as well?
It didn't print out very clearly, but it's the one with my signature, yes.
Is that the, was that the amendment to the lease agreement?
Oh, yes.
Okay. Judge, at this time, I'd like to enter into evidence plaintiff's exhibit number 1.
Okay, Ms. Sisson, do you have any objection to the court accepting plaintiff's 1 as evidence?
Is that the one that says, is that the new agreement they wanted me to sign that says I'm antisocial behavior? Because I did not sign that. That's the contract they gave me. It said I had antisocial behavior that Todd presented to me that I would not sign. How about that?
24-page lease. Do you have copies of these exhibits?
Have a lease. I do have a lease. Yes, ma'am, I do have a lease.
Judge, they were emailed to Ms. Sisson at the same time I emailed them to your assistant.
Okay. All right.
Those were the ones duct taped to my door. He duct taped those to my business door.
Judge, I didn't duct tape anything. I just forwarded them by email to Ms. Sisson at the same time I forwarded them to.
I do see that Monday, January 11th, 10:03 a.m., D. Wood at Doug Wood Law sent this to my assistant, and Robin Sisson at PROFgroomer@gmail. So we're going in order. This is the first of, it looks like 4 PDF attachments, a 24-page lease. And Ms. Sisson, with that clarification, do you have any objection to me admitting this? If I admit it, it doesn't necessarily mean I'm agreeing with either side's version of events. It just means you're both free to discuss what's in that document.
Yes, ma'am.
You agree that I could admit that?
I don't know if their copies. I don't know if their copy is the same as mine.
Okay. Well, again, 24 pages, and it looks like on the 24th page, there are signatures by John Carr and Robin Sisson, purportedly, with 2 witnesses as to each of you.
Well, I have signed a lease with them. I had a original lease to the 2021 of November. I did get, when they gave me the antisocial lease, I wouldn't sign it. So then they said I was a holdover tenant and they're going to sue me then.
This appears to be November the 6th of 2015. Do I have that right, Mr. Wood?
Yes, Judge.
That's what we're looking at. That looks like the date's actually on page 4 because there's a table of contents up front. Made the 6th day of November 2015 between Sandbanks LLC and Robin Sisson, DBA Designer Dogs by Robin. 24 pages signed on page 24.
Yeah, I do have a big lease here.
Do you have any legal objection to the court accepting Exhibit 1?
I guess my answer has to be yes, I have a lease. I just don't know if it's the same one they're giving you. But I do have a lease.
Okay.
Mine is not numbered, so I don't know what page 24 would be.
Okay. All right. Well, these are the documents that were emailed on Monday morning to both of us at the same time.
But mine's not numbered. But these would, in the email, I don't know. I can't pull that up.
Okay.
But this is the paperwork, duct tape to the door.
Look at about the third page.
So all the neighbors can see.
Look at about the third page of it and tell me if it starts off with citing the date as being the 6th of November 2015. Might be the 4th page. Commercial lease agreement. Is that the date of the lease you're looking at?
Yeah, that's what I'm looking at.
Okay, 6th November 2015. Do you have any objection to that document being placed in evidence?
The 6th of November 2015 is a commercial lease agreement that I have in my hand right now.
Any
Is
objection?
that the one you're asking me about?
It is.
No, go ahead. Yes, ma'am.
Do you have any objection to me admitting that in
Yes,
evidence?
I have that one.
Ms. Sisson?
Well, I guess not. I guess it's where they say, no, man, go ahead and admit it. I guess that's where they say they can.
All right. Again,
Yes,
both
ma'am. Go
sides
ahead
can
and admit
discuss the
that.
document. All right, then I'll admit Exhibit 1. Mr. Wood, you may continue.
Thank you. Mr. Card, to your knowledge, was Ms. Sisson ever late with her rent?
Yes, many times.
What about in the past year?
Oh, yes.
To your knowledge, did she timely pay the rent for November 2020?
No.
And do you manage the property yourself, or did you hire someone to manage it?
No, I hire COVA to manage the property. They're professional property managers, and I think they probably do it better than I could do it.
Okay. And is COVA Management still the property manager for the property?
Yes.
When Ms. Sisson did not timely pay rent in November, did you instruct COVA Management to send out a notice?
Yes.
And to your knowledge, did Ms. Sisson comply with that notice?
No.
To your knowledge, did Ms. Sisson ever attempt sometime after that point to deliver an $1,800 check to COVA?
I was told by COVA that she had lodged a check for that amount with them, but it was after. I think you need to talk to COVA. I can't remember exactly.
Okay. And did COVA Management have authority to act on your behalf with regards to Ms. Sisson and her tenancy?
Yes.
Thank you. Judge, I have no more questions of Mr. Carr.
Okay. Ms. Sisson, do you wish to ask any questions, what's called cross-examination of Mr. Carr? Please understand that you'll have a full opportunity to tell me your side once Mr. Wood finishes. So this is not that. You'll get a chance to do that. But do you have any specific questions that you want to ask Mr. Carr about his testimony?
Yes, ma'am, there is.
Go ahead.
Mr. Carr, I would like to know, when you say that I have a history of paying late and you swore to that.
Oh, jeez.
Sorry, I didn't hear. Is that a question?
You got disconnected.
She'll have to come back.
Ms. Sisson, you got disconnected the second you started to ask the question.
Yeah, I'm sorry. I was wanting to know, Mr. Carr swore in a statement that I'm always late, that I've consistently been late on my rent, and I've been there 5 years. These people are so aggressive that's so not true. My problems really didn't. The question is, I would like to know when he says my history of paying late started.
I can only go with what COVA tell me. They collect the rent, and when they tell me that the rent is late, or that it's late and it doesn't cover the amount owed, I can only go with what COVA tells me.
And I'm going to agree. I think Mr. Wood tried to ask some questions of Mr. Carr that are probably better for Ms. Gaglia. So we'll probably get to that with a better witness in just a second. Any other questions for Mr. Carr?
No, obviously he doesn't. He's not up to date with, he's swearing to things that he doesn't really know.
Let's see what Ms. Gaglia knows. Mr. Wood, you want to call her next?
Yes, thank you, Judge. Ms. Gaglia, can you give us your full name for the? Can you give us your full name for the record, please?
Kimberly Ann Gaglia.
And are you currently employed?
I am.
And who are you employed with?
COVA Property Management.
And does COVA Property Management manage the property we're discussing here today?
Yes, sir.
And are you familiar with Ms. Sisson and her tenancy?
Yes, sir.
And what's your position with COVA?
I am the Senior Vice President of Property Management.
Do you have in front of you the exhibits that I emailed to you yesterday?
Yes, I do.
Do you have plaintiff's exhibit 2?
I do. Yes.
Do you recognize that document?
Yes.
Did you prepare it?
Yes.
And what is it?
It is the 3-day notice.
And it says it has a date in there of November 9th of 2020. Is that the date you prepared the document?
It was prepared, yes, and delivered on the 9th.
Okay. And in there, it has an amount that was due for rent of $2,769.30. Did you make the determination that that was the amount that was due at that time?
Yes, that was the balance on the tenant ledger at that time.
Okay, and we'll get to that. How was this 3-day notice delivered to the tenant?
This was mailed certified return receipt.
Okay, and if you look to page 2 of the document, is that the certified mail receipt?
That is.
Judge, at this time, I would like to enter into evidence plaintiff's exhibit number 2.
Okay, Ms. Sisson, any legal objection to plaintiff's 2? This again was in the email. It looks like it's 2 pages, one being a 3-day notice and the second being a copy of some mail receipts. Any objection?
No, go ahead. No, ma'am.
All right, plaintiff's 2 will be received in evidence. Mr. Wood?
Judge. Ms. Gaglia, can you now turn your attention to plaintiff's exhibit number 3?
Yes.
Do you recognize that document?
Yes.
And what is it?
It is the tenant ledger for Ms. Sisson.
And who prepared that document?
That our accounting software spits out the report based on the information put into it. So we pulled this report to prepare the 3-day notice.
Is this a document that your company keeps in the regular course of business with managing the properties?
Yes, it is.
And what does this show, this tenant ledger?
This shows the charges and the payments received.
So in this case, when Ms. Sisson makes a rent payment, that's reflected and entered in here as a payment, is that correct?
Yes, it is.
And the charges, we have different categories. Those are entered as they are charged to the tenant, is that correct?
Yes, on the 1st of the month.
And if you could for me, if you could look at page 2 of this document. And if we go back, or if we go towards the top of the document, the date is July 9th of 2020. And it says NSF reversal. Do you see that?
I do.
What was that related to?
That was a check that was received earlier that we received notification from the bank that there were not sufficient funds.
Yeah, you know, Leona.
So in essence, the check bounced?
Yes,
And when the check bounced in this ledger, you reversed the payment because it has a negative in there,
correct.
which if you look to the right, then increased the category, the balance. And is that the balance that Ms. Sisson owed to the landlord at that time?
It is.
And if we go further down the page, there was another NSF check around September. Is that correct?
That is correct.
And if we go to November 1st, there's a base rent
Yep.
of $947.33. It looks like on November 1st, there were several charges that were entered. Is that correct?
That is correct.
And those charges being the base rent, the sales tax, the CAM charges, and the sales tax on the charges, correct?
Yes.
Okay. And it looks like on November 8th, What's this ACH payment?
That is through the portal that Ms. Sisson went into our system and made a payment of $200.
Okay. And what was that $200 for? Do you know?
I'm assuming it's the balance, the past due rent, a payment on that rent, that balance.
Okay. And that was made through a portal?
Yes.
Okay. And after, so after that date on the 9th, that's when you prepared the 3-day notice?
Yes.
And you prepared the 3-day notice for the amount that was due as of November 9th, 2020?
Correct.
Okay.
Hang
Judge,
on.
at this,
Ms. Sisson left and is back. Okay, she's back.
oh,
It was just for
Do
a
I-
second, Ms. Sisson. I just noticed that you had dropped off. Okay, Mr. Wood, I'm sorry.
she's muted again, Judge.
That's okay.
Okay. At this time, Judge, I'd like to enter into evidence plaintiff's exhibit 3.
All right. Ms. Sisson, any objection to the court receiving plaintiff's 3, the tenant ledger?
Well, what he's saying isn't exactly right. So do I say that it's okay that he can present that? Because that's not exactly how it was.
I can't give you legal advice, but what I can tell you in hopefully an answer to your question is admitting it into evidence does not mean that I accept as gospel what it says. It just allows me to consider what both sides want to tell me about its contents. So you are, if I do admit it, you're still absolutely free to take issue with it and tell me where it's inaccurate. Do you have any objection to
thank
me
you.
admitting
Yes,
it so
ma'am.
you all can debate it?
No, ma'am.
I'll admit
That's fine. Yes, ma'am. Yes.
plaintiff's 3. Thank you.
Ms. Gaglia, can you take a look at plaintiff's exhibit 4 for me, please?
Yes.
Do you recognize that document?
Yes.
What is it?
That is a check that was received by Robin Sisson on the 19th of November.
Okay. Now the check is dated November 19th, but you said it was received on the 19th?
I believe she dropped it off here in the office on that date.
Was the check accepted by COVA?
No.
And did COVA make Ms. Sisson aware of the fact that they weren't accepting the check?
Yes.
And who at COVA made Ms. Sisson aware of that?
My assistant, Leonie.
Do you know how it was she made Ms. Sisson aware of the fact that they weren't accepting the check?
Leonie is here. I know she hasn't been sworn in. Would you like her to answer that?
No, that's okay. If you don't know,
Okay.
you can just say you don't know.
Okay, I'm not sure.
Okay. And do you know if, well, never mind. But, okay. But the check was not accepted by COVA, correct?
Correct.
Judge, I have no further questions.
Okay. And Ms. Sisson, do you wish to ask any questions in cross-examination of Ms. Gaglia?
Well, I've never met her, but I know that the total records they keep are not correct. They overcharged me last year over $200 in my rent. When I went back and caught that, they said they would give me credit on it, but they would tax it first. So I did not allow the taxing. I just took the money that I had already been paid them and taxed, and put it towards my rent. That didn't make them happy.
Okay. I think this
try to stick with
is probably your testimony as opposed to any cross-examination. Let me clarify.
Okay, well, I want to do a cross-examination. I'm sorry to Mrs. I know that her records aren't totally correct, but I have to say that when I got behind, or my check was returned in July, which was the first ever in my life, it was due to my taxes being paid by my accountant which I just became aware of.
I think this is
you know, I
testimony.
caught up.
You're offering me your testimony.
Well, okay,
So
so
hang on just
Right.
1 second. Let me see if I can stop this train. Mr. Wood, what are we doing with plaintiff's exhibit 4?
Yeah, at this time, Judge, I'd like to admit plaintiff's exhibit 4 into evidence.
All right, is that your final exhibit then?
Yes, Judge.
That's all that was sent to me. Ms. Sisson, do you have any objection to the court receiving plaintiff's 4, which is the one-page image of an $1,800 check, purportedly November 19th, 2020? Any objection to that?
no, ma'am, and Leona told me she would accept it. Leona and I spoke, and she said, do not worry about the late fees. They will probably be taken away because you have caught up and you have consistently paid and constantly called. And so the $1,800 check, in my opinion, when Todd took it at COVID, the morning I took it over there, was going to be deposited, and I would be up to date at that point.
Okay, so we're going to just let you go ahead and testify. All right, so point 1 is you were told the $1,800 would be accepted and would make you fully current. Is that your testimony?
That for the late fees, that they would be removed is what Leona said, that the owner was more interested in my rent and that I was paying, and I was paying like every week or every day to catch up. I would be almost there, and by the 10th of the month they would add. They just kept me looking behind and worse than it was. But I am caught up now, and Mr. Woods is really, I think, just there to get more legal fees. But ma'am, I've never been late up until this episode that's affected the whole country, including Naples with no seasonal business. I do understand the laws, but I believe I need to have an exception to that because I am up to date. This is all I have, and they know it.
Okay. All right, Mr. Wood, any cross-examination of Ms. Sisson?
Just a couple of questions. Ms. Sisson, the 3-day notice in this case, which is marked as Plaintiff's Exhibit 2, you received that document, didn't you?
Which one? Because duct tape and tape, and you put major paperwork all over my business door every week. You my business with the paperwork. The one that came in the mail, if that's the one you're talking about, Leona knew that before Thanksgiving that I would be almost caught up on my rent. She was put in there to know exactly what I was doing. I was speaking with her, and when that letter was sent, she told me I would have until the 20th to make that right. She told me that.
Ms. Sisson, the question was, did you receive the
yeah.
notice? Did you receive the notice?
The one that was, I received all of them between being duct taped on my door and in the mail. Yes, ma'am, I did.
Okay, that was the only question.
And then there was always conversation before and after. They always knew, Leona knew exactly how much money, how soon I was going to get caught up, and when it was coming. I talked with them consistently.
Mr. Wood, do you have additional questions?
And I paid.
No, Judge, I don't have any further questions.
All right. Ms. Sisson, did you have anything else that you wanted the court to understand?
Yes, ma'am. I've been very successful there, regardless of how they have tried to get rid of me. I have been voted Reader's Choice Naples Gulf Shore Life #1 groomer in my business. I have those plaques on my wall. I am also in the magazine for Faces of Naples. And I have done very well there, and they've consistently tried through not just now, but with paperwork prior to put me out of the business. and to get rid of me, and I have not understood it as my business is very clean inside and out. And this is, again, Your Honor, it's all I have. I am up to date. I think this is not acceptable at this time, especially with the effort and the continuous communication that I have done with this property management, and that I am up to date.
Okay. All right. Mr. Wood, anything else the plaintiff wants to put before the court?
Judge, just in brief summary, again, Ms. Sisson herself in her answer, her pro se answer here, admitted that as of the date she filed the answer, she admitted in there that she still owed money for November to bring
Only
the rent
for
to date.
late fees.
See,
And it's swear in Leona. Okay, swear in Leona. She knows what was going on. They always knew the money was coming. I never stopped paying. Admitting is not a crime. Not taking care of it would be, but I have.
Okay. Well,
I tried to speak with Mr. Wood. I'm sorry. I'm sorry. That's why this is not my job. I did try to speak with Mr. Wood several different times prior to this, but he made it clear he was not talking to me, and that legal fees was what he was going to get.
Judge,
And
first of all,
that
Judge,
legal
first of
fees
all,
was right because I didn't deserve it.
okay, Ms. Sisson, I hear you. Again, that's one of those many things that the court really ultimately can't rule upon. Mr. Wood, did you have anything else, sir?
Judge, just that, again, I think we've established the case. The amount of rent that was owed in November is undisputed. The three-day notice was prepared, was properly delivered. The defendant did not remit payment or move out within the 3-day period. She did try to make a partial payment several days after the 3-day period expired, which was not accepted. And the plaintiff would request a final judgment instructing the clerk to issue a writ of possession and to release all the money deposited in the clerk registry to the plaintiff. Thank you.
All right, Ms. Sisson, any final statement that you wish to make?
No, ma'am, I'm not admitting I was late. I'm admitting to hardship.
Okay.
I'm telling you, I never, ever, ever quit paying, and I'm caught up now. And for him to take my money is unacceptable. And for them to constantly post me and come into my place of business and tell me I'm antisocial and they have other people to rent to, I feel that the case should be mine because I've been on top of everything.
Okay.
This is hardship. It's exceptional, please.
Well, ultimately, I think both sides. I know it's an emotional and a difficult case. There's no such thing as an easy eviction or an eviction that doesn't have significant consequences for both sides. Ultimately, as I said at the beginning, I'm very limited in what I can actually consider and rule upon. And what ultimately is the main thing that I have to look at here, the plaintiff has followed all of the procedures that Florida law requires in terms of providing notice and establishing that there is a landlord-tenant relationship here. The other piece of the puzzle is whether there was a failure to pay. And let me be very specific there. I'm not allowed to look at any hardship. Hardship, unfortunately, while it makes perfect sense to us when we speak outside of a courtroom, inside of a courtroom, it isn't something I can consider. The ledger, which I think was plaintiff's exhibit 3, is ultimately the most important document for the court. And it reflects that there was not a zero balance since 2015. There has been at least some balance. I think the lowest it got was about 500 and something. And so ultimately, once they have done the 3-day notice, if that amount was not paid on time and in full, the court's inquiry is over. There is nothing else that I'm allowed to consider. I can't look at hardship or mitigation. I can't look at goodwill or ill will or bad intent. It is clear here that, again, Ms. Sisson, even you agree that you were doing your best to catch up and you just had a little bit left to go for November. For purposes of my initial order, I used your figures. And you did, I think, demonstrate some exceptional goodwill in trying to get current from there. But I'm also mindful that the figures I used from you are radically different from the figures the plaintiff has now shown in a day-by-day 5-day ledger, and you are not current. They can charge sales tax, CAM, and tax on the CAM. And once they start litigation, they can charge the attorney's fees. And so current takes on a different definition. The plaintiff here, as much as I may have sympathies for the hard work of a small business owner who's been met with some real success in the community, they have proven what they need to prove here in order to secure the eviction. I am required by law to grant a final judgment in favor of the plaintiff. I will further order that the fees, that the amounts that have been paid into the registry would be dispersed to the plaintiff. Mr. Wood, I don't believe, but correct me if I'm wrong, have you already submitted a proposed order that would do what the court has just found appropriate?
No, but I can submit one to your assistant today.
All right, if you'll please submit that in Word format, that way I can adjust anything if I think I need to. Please be specific. I know you're experienced in this, but please make sure that you're clear as to who the payee should be and the address for the disbursement check from the clerk. I will note one final point, which is this. Ms. Sisson, doing my best to imagine being in your shoes, my next question would be, how fast is this going to happen? And the answer is, as quickly as they decide to try to push it through. If the parties are able to agree on, a deadline for Ms. Sisson to make an exit, that's between the parties. I cannot require them to continue to house your business there for any set period of time after today. If they push this through at the fastest speed, it could be that eviction is achieved within 1 to 2 days. So if the parties agree on something else, you're free to do so, but I cannot require that. That is really everything on which I can rule for the parties today. I certainly wish both sides good luck in a very difficult situation. Mr. Wood, is there anything else that the plaintiff would ask the court to address before we adjourn?
No, that's it, Your Honor. Thank you.
Ms. Sisson, I know you disagree, and I'm sorry. Is there anything else I need to clarify as far as what I have ruled? You're on mute again, ma'am. Still.
I'm not understanding where they're telling you I owe. Can you hear me now?
I can.
Your Honor. I don't understand where they're telling you where I owe a lot of money. The late fees were always promised to be dropped through Leona. So actually, and she told me one thing and they posted another thing. That's all I can say.
Okay. I see a late fee of $250, but a balance of some $2,700. The late fee definitely does not cover what I'm seeing on this ledger. The ledger ultimately is what the court is relying upon. And even if we, if there's a small errors, we've got, again, 2,700 plus that's overdue, a number of non-sufficient funds incidents where the payment had to be reversed. that's going to be sufficient for them to
No,
secure.
there's not a number, man. I don't know where that's not true. I don't have insufficient funds. This is the one check went back because of the tax payment. That was the only time for anything. The
There's a
late
second
fees,
one in
they're not
September.
deducting the $200 that was off.
There's a second one in September.
I'm sorry. What was
Yeah,
that?
there's one in July and one in September, but again, this balance due doesn't even get close to zero at any point. It's not a matter simply of late fees racking.
I know, because they kept adding like the extra month rent, like on the 10th or the 12th. As I would pay, they would add that extra month rent. So it always looked like I was never like almost caught up.
Yeah.
That's the way it was working. I was never even a whole month late because I was paying weekly.
Under Florida law, once you're 1 day late, they can initiate this, and they did, and they've succeeded. So again, I've got additional hearings that will start in about 4 minutes. I don't have anything else that I can conclude.
Can I please ask for 60 days to leave the building?
You
Can I
all
at least ask for 60
other.
days to leave?
Listen, you're free to speak with each other, but the court has no further business, and I cannot require them to give you any grace or any extension. This is not something that was a close call or a difference of a few dollars. This was a pretty clear situation. So I've ruled, Mr. Wood, I will ask you to send the final judgment and either a separate order for disbursement, or it can be a unified part of the final judgment. But if you do that, please make clear at the title of the document that it's a disbursement, because otherwise the clerk.
Will do, Judge.
And please have him make definite ledger on where they think I owe all this money, because Your Honor, I don't owe any other money. I am up to date other than the late fees. And Mr. Woods wants $5,000 in late fees. That's
Okay.
not, I mean, legal fees.
Ms.
That's
Sisson,
not fair.
Today I've got to wrap up, and I need you to stop interrupting me. Today is just about the right to possess the property. I find plaintiff has established the right to retake possession. I've not decided that anybody is owed anything other than the rent that was paid into the court registry will be dispersed to the plaintiff, because that's rent. That's rent that has been earned as this case has been pending, and you have properly paid that. So I'll disperse that to them. That will go toward any balance that may be owed. I may find that it satisfies the balance. I don't know. We're not deciding that today. I've simply decided they've proven that there was not in full on-time payment. That's the end of the question. If it's not paid in full on time, they simply have to go through these procedures and they get the eviction, even if you catch up after the fact. So the law is very, very stern.
Well, they did promise.
I've got the hearing. I've got another hearing that starts in 2 minutes. So I will wish both sides good luck, and the court will be in recess until 11.
Thank you.
Judge.
Thank you.
That's it. It's a hard way.
Okay, good morning, everyone. Welcome to Collier County Court. I'm Judge Martin. I have two matters on my 11 o'clock docket. The first one is Shops at Vanderbilt versus Cerrone. Do I have counsel for the plaintiff present on that?
Roger McMorrow for the plaintiff.
Okay, Mr. McMorrow, good morning. And do I have anybody present for Mr. Cerrone? I'm not sure if I'm saying that correctly. I don't believe so. I think the other gentlemen are both on my other hearing. Mr. McMorrow, I'll invite you to proceed. My last hearing, the defendant showed up about 5 minutes late, but we'll go ahead and proceed on time here, so go ahead.
Thank you, Your Honor. I represent the Shops at Vanderbilt LLC. This is plaintiff's motion for summary judgment on count 2 under the personal guarantee against the individual defendant, Angela Cerrone. As the court may recall, summary judgment was entered against the tenant, the Angela Joseph Cerrone PA, on October 30th. That's document number 16. Subsequent to entry of the judgment, we obtained service of process against the individual defendant. That defendant has been subsequently defaulted. It's undisputed in this case that the defendant signed a personal guarantee agreement guaranteeing the payment of all of the rent of the tenant and the performance by tenant of all conditions under the lease. In this case, we've already established that the tenant owes the landlord $8,969.95 in unpaid rent, $2,450 in attorney's fees, $361.20 in costs, and there's been an additional $160 in costs incurred subsequent to the prior judgment. So we're asking that the court enter summary judgment against the individual defendant, Angela Cerrone, in the amount of $11,941.15.
Okay, Mr. McMorrow, I am familiar. I recall our prior hearing with regard to the corporate defendant, and I have reviewed the file, seen that proper service was achieved and default properly entered, and predictably, the same figures are sought as to the individual, with the exception of that $160 in costs, I think, to get the individuals located and served. So your amounts are properly supported, and there is no genuine issue of material fact. I've already found that those fees are reasonable and would grant you a final judgment as to the individual defendant that will match the one that I granted for the corporation, with the exception, I think, of the $160 in additional costs that have been incurred. Is there anything else that I need to address for the plaintiff at this time?
No, Your Honor, that's everything.
All right. Then I don't believe, Mr. McMorrow, that you've sent final judgment. Correct me if I'm wrong. If not, I'll just invite you to send it along.
It's on the way.
All right, very well. If you'll send that to my assistant in Word format, we can get that done, and then you can simply mail a copy to the defendant, or if you prefer to do a hard copy and enclose stamped envelopes, we'll send it on to the defendant, but we would need envelopes with postage to do that. All right. With that, Mr. McMorrow, I'll let you get back to work. You're all set, sir. Thank you. Looks like he may be frozen. The other two of you I can see moving, so I don't think the issue's on my end. All right. Mr. McMorrow, I think we're all set, sir, unless you have anything else. Okay. All right. I'm going to turn to Popovsky v. Pearson. And I believe I've got counsel for the plaintiff present on that.
Yes, Judge. Good morning.
All right. And how do you pronounce your last name?
Fiore, Judge.
Okay, Mr. Fiore, and let me switch to that file. And then according to the screen name, I believe your client is also on the call, Mr. Popovsky. Am I pronouncing that correctly? Okay. All right. We don't appear to have, I think it was Ms. Pearson on the call yet. Like I said, I had an eviction at 10 where the defendant showed a bit late, but I'm running on time. Mr. Fiore?
Sure. I did receive from your judicial assistant, Your Honor, just a few moments ago, an email and indicate, I'm going to try to pull it up so I can quote it accurately, but the bottom line, I think, is the email that I was forwarded from your JA suggested that the tenant had an emergency and couldn't make the hearing.
Okay, I'm just seeing that. My assistant actually texted me, which is a good idea when I'm in court, texted me that she was sending some emails. So let me take a moment and review those. Okay, and it looks like the client but not counsel was copied on that. So she indicates she's unable to attend, unforeseen family emergency. Monday, January 11th, application reviewed. Okay. Well, Mr. Fiore, there's not a lot of detail here with regard to what the nature of the emergency may be.
I can perhaps add in response, I have received no call from Ms. Pearson. I just checked with Myrna, my assistant here. We don't have any messages or calls or anything.
All right. And I have just, now that I've looked up from reading the email, I've seen that somebody was in the waiting room. Are you Ms. Pearson?
Yes, I am.
Okay. All right. I'm sorry. My head was turned. You might have been in the waiting room for a couple of seconds there. My head was turned looking at.
I apologize.
Okay. So, Ms. Pearson, I was just noting that you had contacted by email my assistant, and I believe copied Mr. Popovsky with a suggestion that you can't attend this morning. You have
Yes,
emergency.
Yes, that's why I'm late. I apologize.
Okay. Are you able to proceed now?
I was told that I had to be here regardless. So I'm here now. So.
Okay. Well, I will say this, if you want to raise a motion to continue, you can do that. Obviously it's at the last second, but you can do that. I don't want to be overly nosy, but I would need to have at least some information. There was no information in the email as to what at least the basic nature of the family emergency might be, so that I can determine whether that is a legitimate basis to continue or not. And then I'll ask Mr. Fiore for his position on that. Do you want to move to continue today, or do you want to go ahead today and simply tell me what's going on?
I mean, I can tell you what's going on regardless, but I'm happy to continue. I just apologize that my nerves are a little shot.
Yeah.
I just came home and I was at my mother's earlier today, and I had come home to get ready for the hearing. And when I got here, my door was open, and I don't know how that happened. And then my dog came out running and got hit by a car.
Okay.
And that happened at about 10:15. And so I tried to contact Mr. Popovsky's attorney, Mr. Fiore, you said?
Yes.
And so did my brother at his office. We couldn't reach him. And I'm the only one that lives here, adult-wise.
Okay.
And so I tried to get a hold of my mother, couldn't get her.
Okay.
And so I just had to make other arrangements once I reached your assistant, and my brother did, and was told that I had to be here regardless.
Okay. Well, yeah, my assistant has sort of only one answer she can really give people, which is she can't rule, and you need to just do what you can to show up and raise it with the judge. Mr. Fiore, let me ask for your thoughts, and I guess I'll note two things.
Sorry.
There's a suggestion in the email I think we've both gotten that there may be money forthcoming from Collier CARES Act. Additionally, I will note that if we do end up continuing the hearing, I would be able to hear it next Wednesday, possibly sooner. I'll double check, but I know next Wednesday had a trial cancel, so I know I have time a week from now. I don't know how you feel about that. And Monday is my other day, and that's a holiday this week, so I guess Wednesday would be the soonest, but I could guarantee you an opportunity to be right back Wednesday. So what are your thoughts, Mr. Fiore?
Well, starting at the beginning, I have not seen any evidence, and I don't think Mr. Popovsky either has seen any evidence of the CDC application or being approved, although as I spoke with him in preparation for the hearing, my understanding is that an application was submitted a while back. I don't think I have the date necessarily, but Mr. Popovsky was working with Ms. Pearson in order to complete an application through the CDC. Mr. Popovsky has completed his part of the paperwork, but as it's been relayed to me, my understanding is that the application just did not move forward, and Mr. Popovsky contacted the CDC assistant in order to find out why the application is not moving forward, and we were led to understand that some documents were not submitted by Ms. Pearson, and that they were still waiting for that, and then as Mr. Popovsky sought further information, he wasn't getting any callbacks. But given the timing of it, this case has been going on for quite a while, and no answer was filed with the court. No effort was made to communicate with us, not successful anyway, in order to try to resolve this or help us get some assistance. But here at the last minute, we're hearing the CDC applications en route, although I don't have any proof of that. And while I can respect the pain, I have pets as well, and I couldn't formally consider them to be family members, but I don't know that that's a family emergency, and I'm not sure what effect that would have on lifting an already entered final judgment and already issued writ of possession in order to delay the hearing. So from the standpoint of delaying the hearing, I'm sure Mr. Popovsky would like to have this case concluded today. From the standpoint of the CDC declaration, I don't see any proof, and I know Mr. Popovsky has worked with Ms. Pearson in order to accomplish that, but we've never been able to do that.
May I say something, sir?
Give me just 1 second.
Okay, sorry.
Let me let Mr. Fiore finish his thought, and I actually
Okay.
had a question, and then I'll hear from you.
Okay.
As it's been relayed to me, and I don't mind asking Mr. Popovsky to testify if the court would like to hear from him directly, but he was receiving payments from Ms. Pearson's father, and I don't think he's ever received a payment from Ms. Pearson. Normally the father, Ms. Pearson's father, would make rental payments, and those payments stopped in March. And no payments have been received since. Ms. Pearson never would make payments. And in addition, there were some other issues that may or may not be relevant given the fact that that the judgment's already been entered. So I don't know that we're necessary. I don't know if the court wants evidence on an eviction necessarily.
No, the writ was issued December 15th. And I'm just curious why there wasn't an eviction executed on the 16th.
Oh, because it doesn't happen that quick, Your Honor. There's no way.
Absolutely it does.
May I answer?
Yeah.
I mean, trust me, you all had a final judgment from me 12/7.
Right.
And I don't know why there was an 8-day delay to get a writ. And I don't know why the writ hadn't been executed any faster than it was. But I deal almost exclusively with evictions. And typically, if I give somebody a final judgment on 12/7, they've got an executed writ on 12/7, 12/8 at the latest, and the sheriff is serving that within 24 hours, unless the plaintiff doesn't move it through. My point being, there didn't appear to be a lot of urgency by the plaintiff here.
Right.
And that was why my order made clear, I don't know why Ms. Pearson ignored this lawsuit for so long, and I don't know why the plaintiff sat around from 12/7 with the full right to retake possession and didn't end up doing it. But now I've got a situation that I will confess I do believe to be appropriate. And we can debate whether our pets are family members, but I will find they are. But the reality is that this, I respect and appreciate it causes Mr. Popovsky some prejudice. Although again, he's had the bird in the hand since 12/7 over a month ago. This is a somewhat manufactured emergency here. But I'm going to continue the case for a week. You all may or may not get CARES money that helps. You may or may not wish to proceed, but next Wednesday I would reset this hearing, and I would note that Ms. Pearson only has one issue before the court. Either she can establish that she has complied and that her CDC declaration is well taken, or she can't. If she can't, she's evictable that day. The writ's already issued. And if she can establish it, then she would secure at the moment protection from actual execution of the writ until the CDC expires, which at the moment is set to happen in a few weeks, January 31st. Now, a lot of speculation suggests that may get extended, but again, everything would rest on whether I find that that declaration is well taken or not. That's the only issue, Mr. Fiore, in response to your question. All other issues have been decided and are final. So there's no need to prove a lawful basis for this eviction at this point. Ms. Pearson, in light of that, what do you want to say? And then I think I'll probably wrap us up here.
Okay, I have just a few things. I'll try to keep them as brief as possible. What Mr. Fiore had stated about Mr. Popovsky having spoken to Collier Cares and not having any proof of communication on my behalf. Like, he had spoken with them as recently as January 1st and was told from them directly, and I have email threads between all three of us, that everything was turned in on my behalf and his, and that I have a new lease established. It's month to month, but a new lease as of October 31st, 2020. So there's a new lease now.
It sounds like it's before the eviction. October of 2020, you've been evicted since then. You have a final judgment of eviction against you. The eviction is not something on reopening. You've just,
So I don't know.
managed to have me stay the writ of possession based on CDC.
The reason, may I finish? I'm so sorry. I'm confused as to why we're here, because in order for him to accept the money from Collier Cares, their terms were he had to give me a new lease. So he reissued one to me and backdated it.
You all may need to take that up with Collier Cares. Now she's dropped off. Hold on. If this is like my last hearing, she'll be back on in a second here.
Your Honor, if I may, and I'm not going to cover any case-related stuff since Ms. Peters is not here, but just so I'm trying to check my records in order to address the informal question, perhaps. Judge, when we get an issued writ of possession, I have to mail a check to the sheriff. There's no way I could know. How does it done in Collier County? Is it that
walk it right on through? You can take my final judgment down to the clerk, get the writ, walk it across, deliver the check. Believe me, eviction
I'm in Tampa, Judge.
Yeah, it's now you can use the mail if you prefer.
I'm in Tampa. There's no way I can do that. So certainly I could not have gotten an eviction in the next day. I don't know
where Mr. Popovsky is, and that's okay. That's up to you. You could take 6 months to walk this thing through or mail this thing through if you like. But again, this is something that the court treats as a same-day 911 level emergency. I try to get these things signed as quickly as possible when presented. And then there was a lengthy delay. I've got an iPhone signing back in here. Okay. You're on.
My phone decided to quit. I'm so sorry.
Okay. All right. You are back on, Ms. Pearson. And I'll confess, I'm not sure what you were saying when you were.
I'm so sorry. I had to go get a charger. I apologize.
Okay.
What I was saying was for Mr. Popovsky to receive the Collier Cares grant of $10,000, which is the maximum they'll pay out for past due and future rent. he had to reissue or backdate a lease. And that was the whole reason that he didn't get paid initially, was because he wanted to see some form of payment before issuing me a lease, because my lease expired before they were going to pay him. And so he was not going to, issue a new lease before seeing money in his pocket. And that's why I ended up getting an eviction notice.
Okay.
And
So
I
did he
totally,
change
I
his
agreed with
mind?
him.
Did he
I'm
change
sorry?
his mind and give you a lease afterward?
So he ended up filing for eviction. And then after realizing that, okay, if he just let me stay for another 30 days, he was going to end up with $10,000 instead of having to, go through the courts and fight. Then he said, fine, I'll just sign your paper for a month to month and I'll backdate it. Then he did so. And he realized, okay, now I'm going to have to wait a little bit longer than January 1st to get paid, but okay. And so I don't know if he didn't discuss this with Mr. Fiore, but I have all the email threads since December 30th, 31st, and January 1st. There are like 3 or 4 of us, 2 Collier County commissioners, myself, and Mr. Popovsky.
When are you saying that the new lease was executed?
I'm so sorry?
When was the new lease executed that you're describing to me?
It was backdated to when my old lease expired, which was on Halloween of 2020.
But when was that actually done? In December?
I would say, it was December 9th.
Do you have a
maybe.
copy of that?
I'm so sorry?
Do you have a copy of that?
Of course I do.
Okay. Mr. Fiore, are you aware of any of that?
I'm aware of that. I'm not aware of the timing, and I'd like to hear from Mr. Popovsky. And given Ms. Pearson's testimony, am I to understand perhaps that we're having the hearing and not going to postpone it? Because I don't.
I just wanted to.
We meandered a little bit.
Well, I don't sense that this is really that she's able to continue. I don't understand why.
I was just trying to clarify what you had said.
Yeah.
What you had stated wasn't true, so I just wanted to correct it
and
before we departed.
I'm glad we did, but it doesn't appear as though we couldn't continue with the hearing.
I'm just a little shaken up in the way I'm talking isn't how my normal stature and demeanor would be.
Let's do this. Ms. Pearson and Mr. Popovsky, you'll have to switch hands, Ms. Pearson, but let me have you both raise the right hand. Let's get you sworn in and let's see if we can at least get things addressed for you today. Do you both solemnly swear and affirm that your testimony before the court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay. All right, you can put your hands down. And Ms. Pearson, I'm going to turn to Ms. Popovsky in a second. Now that you're sworn, do you reaffirm what you have told me, that there has been ongoing communication by email throughout the month of December, and that there has actually been execution of a new lease backdated to the old expiration date in order to meet the requests of the Collier Cares people?
Are you asking me or Mr. Fiore?
I am. I'm asking you to reconfirm your testimony now that you're under oath.
Oh, yes, ma'am. It's true.
Was my statement accurate?
Yes, ma'am.
All right. And Mr. Fiore, do you want to ask a few questions of your client along those lines? That may go to an issue that the court needs to address. So I think we should look at that.
Sure. Mr. Popovsky,
So sorry.
There you go.
I'm going to just I'll mute Ms. Pearson for the time being. Go ahead, Mr. Fiore.
Okay, thank you, Your Honor. Mr. Popovsky, you've heard the testimony so far. I know you've been sitting there listening. Could you tell us your thoughts, please, about this lease and the application through the CDC that you've heard testified to this morning?
Sure. I would like to give a timeline of what actually happened. We had the writ of possession, and the sheriff came to evict Ms. Pearson on the 28th. Then the sheriff was told from the judge that he should stop the eviction, and that something being stopped on your end. realized that there was like a CDC declaration being applied, but I never received any. I was never aware that the declaration was applied. I looked at the list of what the declaration consists of, and one of the things was that the tenant is supposed to give a proof that she made an effort to get a rental assistance from agency to pay the rent. I called in Collier County and I said, okay, is there any rental application applied for my address? And they said it is, but we need additional documents. I said, what documents do you need? They said, we need a ledger from you, what the rent is owed, and we need another lease month to month in order for this to proceed. And they said, we need 2 more documents from Mrs. Pearson that they needed. So I submitted everything just so the application can go through, and the tenant is not gonna blame me on not submitting my part of the order. So I submitted that back a month-to-month rental agreement that they requested from the Collier County. But the tenant still owed 2 documents as of January, which doesn't prove that she submitted that she did everything that's in her ability to provide a payment through the agency. So she wasn't compliant on that account. Plus, she never paid $1 since March to the rent. And one of the points on the CDC declaration is that she needs to make an effort to do a partial payment or anything. She didn't do any of that. She had plenty of time to find a way to get a rental assistance or payment, but she didn't. As of the new rental agreement that I issued, the rental agreement to be completed, they need to be approved from the condo association. Without the condo association, I don't think she went there to get approved by the condo association. Just my lease is not really complete. It's not a complete kind of document for her to stay in the condo. Like it needs to be approved by the condo. I don't own an individual house. It's a condo association, so it needs to be approved. And I don't think she made any effort to do that.
Okay. Ms. Pearson, is it your understanding that you have given Collier Cares everything they need, or do you still need to get them something? You've got to unmute now.
Sorry, I had to unmute myself. I was working directly with Lisa Carr since, I guess it was the 2nd week of December. And I wish I had my computer. It's actually at my mother's house, and otherwise I'd pull it up next to me. Unless we're meeting again on Wednesday, or I can email it to all parties involved. I would love to share the email threads between Lisa Carr and Ivanka, I forget what her last name is, but she's the director for Collier Cares, and myself, where it shows that until 5/31, that's when I submitted the last document on December 31st, that was needed. And the reason that there was a short delay on the 2 documents that were needed from me and was because I've been working with legal aid of Collier County on my 2 tax returns from 2018 and 2019, because the father of my 2 children had claimed my 2 children on his tax returns when he shouldn't have. So one of the 2 documents was they wanted me to show that I had received my stimulus check, but I didn't receive it because I didn't file 2018 or 2019. So I didn't receive it for myself or the children because he got it for the kids. And the other document was that they wanted to see 2018 or 2019 tax return, which I was told by the IRS not to file because were doing an audit on him because he incorrectly filed claiming the children.
Let me dial this back. All my question was is it your understanding that you have submitted everything that Collier Cares requires? And I think your answer was you submitted everything as of 12/31. Do I have that
Yes.
right?
Yes. So it just took till 5:31 p.m.
Okay. All right. So, Mr. Fiore, I guess we've got a couple questions. It sounds at least possible that something like $10,000 could be around the corner for your client. But in order for him to enjoy that, we can't proceed with the eviction. It would be very, very, very bad faith, I think, for this court to proceed and Mr. Popovsky to get the money. Now, he may be owed more than $10,000, but again, strictly speaking, once you move to litigation on an eviction, you close the door on any payments coming in. If you take the payment, you got to ditch the eviction. So I don't know which pathway you all wish to pursue, but if Mr. Popovsky does wish to, and his actions suggest he does, wish to comply with CARES in order perhaps to get some money, it may be his best chance to get at least partial payment, then I don't think we can support the eviction. It may be that he can restart the eviction, February 1st, but we seem to have a fork in the road. Do you want a chance to speak with him, Mr. Fiore, or what are you thinking?
Thank you, Your Honor. I would like to ask Mr. Popovsky a couple of questions.
Okay.
Given that I hear now that the paperwork was submitted December 31st, we're now January 13th. I'm curious about two things. When is the last time Mr. Popovsky spoke with Collier Cares? I thought I heard him say he did sometime in January, but I wanted to confirm that. Is that correct, Mr. Popovsky?
I need to take a look at when I contacted them, but it could have been in December, in January. I don't think I heard back from them. They never returned the call. But my point is, when the eviction was stopped in December 28th, Jessica Pearson did not have all the documents submitted in the CDC. If she submitted it in December 31st, at the time of the eviction on the 28th, she was not compliant. She did not do everything in her power to get the payment. So although it's painful for $10,000 to not to get them, I don't believe I'm gonna get them. This has been dragging for so long, and I would like to continue with the eviction. And if we can get the sheriff back to evict her,
Right.
I would forfeit the money. It's been too painful for me. I'm sorry.
Okay, so I think that answers the second question as well. I just wanted to say, while Ms. Pearson might not have been in compliance on the 28th, she may be now. We don't. That's my question, is whether she is now. And I'm not hearing proof, at least on my end. The court is the ultimate arbitrator of what the proof is, but I'm hearing allegations that the documents have been filed. We're now almost 2 weeks into January. And Mr. Popovsky, if you haven't been contacted, if your calls are not being returned, I'm just a little suspect that the application is complete and that money's coming. I'm not seeing the proof from Ms. Pearson of that.
May I speak?
No, actually, why don't I jump in here? Because I know I'm taking up a lot of time from all of you. Here's what shapes up. It's a unique situation, and I'll be very candid. Both sides deserve some sympathy. Both sides have significant hardship, and I'm very respectful of that. What I think I could do, Mr. Fiore, as a way to try to respect what I think is a good faith effort on both sides, it may or may not prove successful for one side or the other, but I think everybody is trying to do the best they can. Ms. Pearson has given me, I think, a reasonable explanation for why some of the documents didn't hit earlier based on the tax situation. But Mr. Fiore, if you wanted, I'm considering the possibility that I grant the continuance for just the 1 week, but if Mr. Fiore wanted to craft an order, I would sign it, and we could perhaps do an order that directs Collier Cares to tell us precisely what the status is of the application. Do they
That
have,
would be great.
and what is the amount, and when is it likely to be paid? if we were able to confirm that each side has submitted what they need, that the application's either been approved or denied, and what the amount and the timing would be, then I think when we meet next week, we'll know whether we've got something here that makes sense or not. And if the CARES money is a dead end, then we could just proceed with the CDC.
You won't even have to evict me. I'll just leave.
Ma'am, I'm speaking. Stop interrupting.
Sorry.
Again. We could proceed with the hearing to see if the CDC declaration is appropriate. It was absolutely done in maximum drama last second. If you read my order, you know that I was also somewhat annoyed that after hours on a 4-day holiday weekend, this maneuver was made. But if the CDC declaration's proper, we are all on hold. And if it's not proper, the eviction will happen immediately. But if there is a third pathway, which is CARES money, let's pin that down. And Mr. Popovsky can either opt in to get the CARES money, or he can opt out, potentially secure an immediate eviction. But I will make clear to the CARES folks that there's been an eviction and there should not be a payment. I don't think Mr. Popovsky should get an eviction and a payment. That is, to my understanding, very inconsistent with that CARES money. That's why they demanded a lease in order to entertain the application. So we've got three choices as I see it, and I would give us a week to let Ms. Pearson catch her breath, deal with her emergency, and I would offer to sign for Mr. Popovsky a court order demanding that Collier Cares give us a precise update on where this thing stands. Mr. Fiore, what are your thoughts on the court's suggestion there?
I'd be inclined to agree to either one of them, and I'd defer to my client to direct me accordingly. I might ask the court whether, and maybe I'm asking for clarification. Clearly, the court wouldn't have suggested this if it wasn't appropriate, but would it be appropriate for us to order Collier Cares to do something, or should we order the tenant to provide the information by calling Collier County?
No, I want Collier Cares. I'd like a court order that goes straight to the horse's mouth, and I don't need to know personal financial information, but I'll order the Collier Cares director to verify the status of the application, whether any further documents are required from either party, whether the application's been approved or is still pending, what amount has been approved if it's been approved, and what the estimated timing would be. I'm curious if they would confirm that both sides have given me what we need now. We've approved payment and we expect it to be made in the amount of $10,000 somewhere in the next 2 weeks. That's what I'm foreseeing as a possible answer. And then Mr. Popovsky would need to just let me know, does he want to pursue that or pursue eviction? But if he pursues eviction, then I think it is incumbent on the court to ensure that Collier Cares knows this is not an appropriate payout. I don't think it's fair if Mr. Popovsky gets eviction and payout. That is, again, it may be that he's owed the money from Ms. Pearson, but CARES has made very clear that they're not going to pay for evictions. They're going to pay for housing.
Oh, I 100% agree, Your Honor. And I don't think Mr. Popovsky was under the impression that he was anticipating any money. And we could hear from him really directly. I think if he's given the choice, I think he testified previously, he'd rather turn down the money and secure an eviction.
Okay.
So if the court order were to say, even if the application is approved, Mr. Popovsky is not to get that money, I think he's made that decision today.
You want to turn down $10,000 cash in order to have an eviction, Mr. Popovsky?
They had a long time to pay something they didn't do. I don't believe they're going to give any money to tell you. I would love to get paid because that's money that's owed to me. It's nothing to do with the eviction. She stayed there. The money, the situation with COVID is what it is.
I understand. But I'm offering you the opportunity for me to do a court order to require them to give you a clear, unequivocal answer, whether they're going to pay you or not. And then you could make the choice as to whether you want the payment or the eviction. So it sounded like just then you said, I'd like the payment, I just don't trust it's going to happen. And I'm telling you, I'll do a court order to have them tell us if it's going to happen.
Appreciate your honor. It's very generous of you for doing the extra effort, and let's try to do that, what you suggested. We'll
It
see.
only costs us a week, and you've been very patient for a very long time, but then you'll have some certainty, you'll have a known quantity, and obviously whatever choice you make, you make. Again, if you opt into the money, assuming that Collier Cares verifies that it's forthcoming, and I have been dealing with a lot of landlords who have been paid. If you opt into the money, then we would stop the eviction. If you opt out, then we would proceed next week with, does the CDC declaration hold water for Ms. Pearson or not? If it does, she would be protected for as long as the CDC carries on with their moratorium. And if it doesn't hold water, she would be evicted essentially immediately. Those are the three pathways that we would explore 1 week from now under what I'm proposing.
Okay, I'll accept that. Thank you.
Ms. Pearson, I really don't want to take more testimony, but do you understand the three possibilities of what I've laid out that we would explore next week?
Yes, I just have a few questions. I'll keep them very quick. One, may I forward the emails that I have between the county and myself to all parties involved?
You may.
Thank you. How do I get them to you?
Same way you made your motion today. I would say that you send it to my assistant, copying Mr. Popovsky, and he can share it with his attorney, or Mr. Fiore, if you want, we can give her your email and it could go directly to you. That's probably more proper.
I think I could do it as a pro se attorney through the portal, correct?
Yes, you can file it and upload it to the court file. Be careful about your private financial information, things like social security numbers.
Got it.
You want to be careful about putting that in the court file, but you can feel free to share that with Mr. Fiore and with the court. Again, what I ultimately will end up being able to do with that remains to be seen, but you certainly can submit those as exhibits for our consideration between now and next week and at next week's hearing.
All right. I did want to apologize about the late filing on the 28th. I was notified when they came to evict on the 28th that after the officer was here, he said, 9 times out of 10 ends in eviction, but you could try to go to the courthouse. I didn't have a way there until about 4 o'clock. There were 2 people working downstairs and they didn't see me until 5 o'clock. So I waited an hour to be seen and then it was already closed. So I do apologize. They just didn't get it in until they were closed.
But again, you were served with the lawsuit quite a while before then.
Right. And I didn't even hear, I got the paperwork in November, but then I never heard another thing about it until that officer showed up. Yeah. So it just didn't even click.
Because you were busy being evicted. I mean,
no, because I had been busy working with Collier Cares and talking to Mr. Popovsky about how do we make this work.
Okay.
So in my head, it was get him the money, not get kicked out.
Next time you get papers from a court that tell you got 5 days to respond or forever hold your peace, you want to make sure to respond to the court. Okay. That's how you protect your
Hopefully
rights.
it'll never happen again.
It's a mistake that others have made, but we are where we are and we're going to go forward. Let me just pick a time for next week that will work hopefully for everyone. I'm looking at Wednesday, January 20th. And I might propose that we aim for about the same time, 11 a.m. next Wednesday. Looks like it should work well on my end. Does that work, Mr. Fiore, for you?
Yes, Your Honor, I'm available at that time.
Mr. Popovsky, 11 a.m. next Wednesday, thumbs up. Ms. Pearson, same time next week. Okay, then let's do that. The court will do a notice of hearing indicating I'm granting defendant's motion to continue. Mr. Fiore, I would simply ask for, I'll take care of the notice of hearing and the order that grants the continuance, but I would ask for you to forward an order. I've given a rough outline. If you decide there are other points we want Collier Cares to answer, include that in your draft and just send that to my assistant. I'll try to get that out. Like to get it over to Collier Cares today so they've got the week. It's a tight timeline for them, but they should be able to answer those questions quickly for us.
So too, Judge. Thank you for that. I'll take care of that.
Okay. All right. So Mr. Fiore will do the order for Collier Cares. Get that to me. I'll do the order that resets us to 11 a.m. on Wednesday the 20th. And we'll reconvene in a week. Hopefully, maybe we can find something that's mutually acceptable. And if not, then we'll be prepared to go forward with the evidentiary hearing on the CDC declaration. With that, I'll let everybody get back to their business. Ms. Pearson, good luck with your, sorry you're having a
Thank
difficult.
you.
Everybody, good luck. I'll see